case caption State of Ohio, D. Gerlosky, case number 23CR000002. We were last here on May 4th, at which time the defendant entered a written and oral plea of guilty to count 1, weapons under disability, a felony of the 3rd degree in violation of 2923.13A4 with an accompanying forfeiture specification here regarding contraband or instrumentality, specifically the instrumentalities, and then count 4, possession of cocaine, a felony of the 5th degree in violation of revised code section 292511 with an accompanying forfeiture specification regarding the contraband or instrumentalities related to that count. Count 6, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination, a misdemeanor of the 1st degree in violation of 4511.19A1A of the revised code. And count 7, that being possession of cocaine, a felony of the 5th degree in violation of 292511 with an accompanying forfeiture specification. Those forfeiture specifications being pursuant to 2941.1417 and 2981.04. At that time, the case was referred for a pre-sentence report and investigation and drug and alcohol evaluation. Those have been completed. We are here today for purposes of sentencing, and the defendant is present with his counsel, Mr. Ken Rubenstein.
Thank you. All right, Mr. Rubenstein, any reason not to go forward with sentencing?
No, Your Honor.
Anything you would like to say on behalf of your client?
Yes, I would, Your Honor.
Go ahead.
My client takes full responsibility for his actions. He realizes that he's got a drug issue and a mental health issue. He has been working. He also has insurance to cover some of the expenses for any kind of treatment. My client is a skilled worker. He's worked and can work. He actually has a job that he can go back to if he can, if he can get through everything here. My client is anxious to seek treatment for both his substance abuse as well as mental health. He realizes how important it is to stick to all treatment plans and not deviate from them. And I believe if you give him the opportunity with some treatment, I believe my client can go back out, become a productive member of society, and stay out of the system.
Mr. Gerlosky, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, Your Honor. I would just like to say that, yes, I do take accountability for my actions, and I know that I should not have had the weapon. The gun was actually left to me by my uncle when he passed away. We used to go shooting together. He was living with us for his last 6 months before he passed away. I know I shouldn't have had the gun with me, but when I got kicked out that night, it was in with my property.
No, it was in your waistband, loaded with one in the chamber.
It wasn't in my waistband, but I'm not going to argue with it, though. But I take accountability. I should not have had it in the first place.
Protruding from your left pants pocket.
Yeah.
I'm sorry.
It's okay.
It's about 2 inches away from your waistband.
That's not really where it was found at, but
Well, how do you know?
when I was there.
I don't think your mind was there. Go ahead.
Understandable. I'm not arguing. I'm sorry. I still, either way, should not have had it, and I take responsibility for that. And also, with the mental health and the drug addiction, this is the first time that I've actually followed the recommendations to follow up and was diagnosed at Signature Health. So they want me to start on medicine for my bipolar, and I'm willing to follow those recommendations along with the addiction counseling. And I think that if I do that and go back to work, that I would be able to be a productive member of society and be there for my daughter.
there anything else you care to have the court consider?
No, Your Honor.
Ms. Linden for the state of Ohio.
Thank you, Your Honor. Your Honor, in terms of this particular case, looking at some of the facts and circumstances, I know that when we look at whether something is more or less serious, the fact here that these incidents occurred within 4 days of each other, and the first one, and I believe it was his mom who called and said that she had seen the defendant with his eyes rolled back in his head, gasping for air, and pulled him out of the car. And when the police did arrive, he did then end up having the firearm on his person, and there were 12 rounds in the magazine and 1 loaded in the chamber. He had a twisted T in the center console. There was white powder on the passenger floor. There were drugs in the car. And then he had to be taken to Lake West, and that didn't obviously make that much of an impression because then 4 days later he's in an accident with a deer and he has a pipe in his car again. And so it's clear looking at that and then looking at his 2018 case being a possession of cocaine and the statements that are listed in the report in the officer's discussion with the defendant's mother that the defendant does have a long history of drug use and clearly he needs to have some treatment. It does appear, as we discussed in chambers, that when he's been on probation, he has been able to follow through, so clearly that's something that's necessary. We would ask that he be in some long-term treatment. There is a mandatory driver's license suspension on the misdemeanor as well, since it is related to the drug charge of 1 to 7 years. We would ask for the forfeiture.
Wait. Since it's related to the drug charge, it's an
The-
OVI.
The OVI, but because drugs are related, my understanding is that
Yeah,
if that's the case, then it's 1 to 7 years for the driver's license suspension. It's mandatory.
On the OVI?
That's what we
The
talked
OVI has a license suspension,
Right.
and then the drug charge has its own separate
Right. But
and that's mandatory because it was
Because
in
it was-
conjunction with driving, but it's up to 5 years.
I thought it was up to. I thought we talked about it being from 1 to 7, but perhaps I'm
Not for the
mistaken
drug
on
charge
that.
or for the OVI?
For the OVI.
Oh, I don't know. I have to look
I'll
at
have to take
that.
a look at that.
I don't think that has anything to do with.
Okay. Well, there is a mandatory license suspension, and the firearm is subject to forfeiture as well. So looking at those factors under 29, 29, 12, B, C, D, and E, in terms of looking at what's more serious, I've addressed that, but in the recidivism factors, then he does have a history of criminal convictions. He hasn't responded favorably, or at least hasn't applied the tools continuously that he learned before, and he does have a drug and alcohol issue along with a mental health issue that clearly needs to be addressed. So we would ask that those be part of his probation, and he does have 29 days of credit for time served. There was an additional there was 1 day initially, and then the time frame that he's been in jail since his bond revocation for the positive screen.
Thank you. 1 to 7 years because it's his second DUI in 10 years. That has nothing to do with the drug charge.
Okay.
Normally, I think it's 1 to, I can't remember
One
what
to
it is.
three, if I remember. Right.
Sorry?
I think it's 1 to 3 if it's a first
Right, and then,
offense.
but it's 1 to 7 because it's his second.
Second, right.
And then there's a separate mandatory suspension on the drug charge of up to 5 years. Now, those can be concurrent with each other, but that's, normally the drug charge is not mandatory license suspension, but it is if it's in connection with an OVI. That's what you were, I believe. But it doesn't make it more years. All right. This court did review the pre-sentence report and investigation, the drug and alcohol evaluation. I reviewed the PSR from 2018 as well. That was prepared with the last time that you were on probation. I've considered the particular facts and circumstances of the offenses involved in these two separate incidents, the nature of these offenses. I consider everything that's been said here today by Mr. Rubenstein, the defendant himself, the prosecutor. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911. Factors in 2912, factors indicating the conduct is more or less serious than what normally constitutes the commission of the offenses. The court notes for the weapons under disability charge that the weapon was loaded with 1 round in the chamber and was in possession of the defendant. Now, most of the normal weapons under disability cases we have, the person's actually not in physical possession of it. It's in their car somewhere. They have constructive possession of it. I shouldn't say they're not in possession of it because obviously they're possessing it for purposes of that offense, but it's not on their person loaded with round chambered. And the defendant's condition that he was in at the time, being under the influence, makes that conduct more serious. Nothing makes it less serious. As for the incident that occurred on December 2nd, which would be felony charge would be count 7, the possession of cocaine charge. The court finds this more serious as the defendant was operating a vehicle at the time when this offense was committed, which not only puts himself at danger, but puts people in the community at danger and at risk. And that makes that more serious. There's nothing that makes either of these offenses less serious than normal. As for recidivism factors, court finds the defendant has a history of criminal convictions. He has been on probation before in the past here in Lake County for similar type of offense, possession of cocaine charge. Record goes back 10 years to 2012. He's got other convictions, felony convictions out of Cuyahoga County. Drug abuse problem that relates to the commission of the offense, and I'm not sure how much the defendant really gets that he's got guy has a bad issue here. These two offenses were committed within 4 days of each other. You also tested positive for drugs. I think every drug we test for, perhaps. Tested positive for cocaine, fentanyl, amphetamine, methamphetamine. When you were here after your change of plea, tested positive again when you came back for your interview for cocaine. There's a significant issue here that I just don't know if the defendant gets it. No genuine remorse in regards to the commission of the offense. As for factors indicating recidivism is less likely, none of those are present. These are findings for both cases under the recidivism factors. Under 29-29-13, well, strike that. Count 1 is a felony of the 3rd degree, so there's no presumptions either way in regards to probation or prison. I recognize that you did well on probation the last time you were on probation, but as soon as you got off, you went back to your old ways.
I was up for 2 years.
That's true. You got off in 2020. No issues again until 2022, but I'm not sure what happened to get you back on this track, but you fell hard. I'll give you a chance to try to prove yourself again and get back on the right track, but I mean, you need some help here.
I agree.
I'll find that you're amenable to an available community control sanction. I'm going to place you on community control sanctions for a period of 2 years. I'm going to order that you serve 90 days in the Lake County Jail. You have credit for 29 you've already served. I'm going to order that the defendant immediately enter as soon as he can the jail treatment program, successfully complete that program. Upon completion of that program, he is to enter and participate in the program at NeoCap and follow all their aftercare recommendations. I'll allow him to be released from the jail as soon as a bed's available at NeoCap after he's completed JTP. He's to successfully complete the program at NeoCap. Again, follow all their aftercare recommendations. He is then, at this point, I'll probably vacate this order, but you're to return to the jail for 30 days to be in the transitional day reporting program. Now, you probably wanted to do that, but that's a program that helps people make the transition from being locked up to being on their own. Instead of just opening the doors and saying, you're free to go, a lot of people have nowhere to go. They have nowhere to go to live. They don't have work set up. And if that's the case, this is a nice program that helps people find somewhere to work, find somewhere to live. Now, if that stuff's all in place for you at the time you get out of NeoCap, and that's something you can work on while you're at NeoCap, then I'll vacate those 30 days and you won't have to do it. But it's a nice program to have in place in case you find yourself in that position. And I put it in place for everybody that goes in NeoCap, just in case they find themselves in that spot.
Okay.
But probation will notify me if you've got your housing lined up and work lined up. They'll notify me and I'll vacate that. The other conditions, you're not to use any drugs or alcohol. You have to submit random urine screens. They have to be negative. A positive screen's a violation. You can't screw around or tamper with the urine samples, bring in someone else's urine or fake urine or anything like that. That's a worse violation, quite frankly, than testing positive in my book. You're to attend 3 AA meetings a week or NA meetings and have a sponsor. To obtain a mental health assessment, follow all recommendations for any mental health counseling. I want you to get a psychiatric assessment also, to determine whether any medications could be beneficial for you, and follow their recommendations and take all medications as prescribed. You'd only have one doctor and one dentist that could prescribe you medication. If you have a specialist, that's fine too, but only those doctors that you tell probation about and that they're aware of that can give you prescriptions. If you get a prescription from some other doctor that they don't know about, that's a violation. You can only get your prescriptions filled at one pharmacy. They need to know where that, they need to know where that is as well. You're to pay your court costs and supervision fees. On count 6, the OVI, there's a mandatory fine that I must impose of at least $575, and I'll impose that fine. I won't do more, but it'll be $575. Counts 6 and 7, there's a mandatory license suspension. I'll suspend your license for 18 months on each count, but it's concurrent suspension. I'm going to forfeit contraband and instrumentality set forth in the specification. I'll dismiss the remaining counts of the indictment as agreed to. I will order that bond be released, as it was only revoked because of the positive screen, not because of the defendant's failure to appear. Ms. Henley, anything else I should be thinking about?
No, Your Honor, thank you.
So, Mr. Gerlach, you understand all the conditions of your probation?
Yes.
Any questions for me?
No.
I need to advise you that if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate your probation will be filed. If it's found that you did violate, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order that you serve more time in jail, or I could terminate your probation and send you to prison. If I did that, it would be 36 months on count 1. It would be 12 months on counts 4 and 7. All those prison terms would be served consecutive, so possibly 5 years in prison hanging over your head. You understand that?
Understand.
All right. Ms. Linden, is there anything else I need to address?
No, Your Honor, thank you.
Mr. Rubenstein, on behalf of the defense?
No, Your Honor, thank you
All
very
right,
much.
thank you.
We're here in the matter of the State of Ohio versus Michelle L. Penn. This is case number 22 CR 858. Ms. Penn is present in court. She's accompanied by her attorney, Ms. Mary Springer. After conversation with defense counsel, it's my understanding that we have resolved this case and present to the court the following resolution, whereby the defendant would tender a plea of guilty to count 2 of the indictment, vehicular assault, felony of the 4th degree, and count 3, operating a vehicle under the influence of alcohol or drug abuse or a combination of them, a misdemeanor of the 2nd degree. The state would then move the court.
Misdemeanor of the 2nd degree?
I'm sorry, first degree. First degree. She's pleading to count 2 and count 3 as indicted. The state would then move for a dismissal of count 1 of the indictment and ask that the matter be set over for pre-sentence investigation report and sentencing at a later date.
Thank you. No agreement between the
No
parties
agreement.
regarding any recommendations?
No, there's no agreement.
Ms. Springer, does that sound accurate?
Yes, it does, Your Honor. There was previously a motion to suppress filed by the defense. We would withdraw that motion upon the entering of the guilty plea here today.
Okay, thank you.
Thank you.
Ms. Penn, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this afternoon?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your formally entered plea of not guilty to counts 2 and 3 of the indictment, and I'll go over those with you to make sure you understand what those entail, and to plead guilty to those 2 charges. Count 1 would then get dismissed. We would defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation as well, and then come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe would be the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here today?
Yes, Your Honor.
Well, before this court can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what you're charged with in pleading guilty to, all the rights you have and all the rights you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I am going to ask you a series of questions. Now, if at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you can ask her questions, or even if you want to ask me questions, make sure you let me know that because I need to make sure you understand everything going on, all right? All right. Let's get started then. How old are you, ma'am?
50.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Before you came into court here today, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
I have prescribed medicine.
Is that what I see written down here? It says mental health medication?
Yes.
What is it exactly you take in the last couple days?
I don't remember what it's called, but I take it on a daily basis.
Just one pill?
3.
3 different? So you would have taken all 3 of those this morning? Or do you take them at night?
I take 2 at night and 1 in the morning.
Okay, so you took 2 last night and then 1 this morning?
Yes.
Do any of these medications affect your ability to understand or appreciate where you are, what's going on, or to communicate anything negative in that
No,
fact?
sir.
Okay. So you're not under the influence of any of these medications right now, which is hindering your ability to understand where you are and what's going on, understand me, anything like that?
No.
All right. Now, you should have, I know you did, you received a copy of the indictment in this case probably around the beginning of December of last year. Do you remember getting that? That's the document that sets forth the 3 charges you're accused of committing.
Yes, sir.
Now, in that indictment, I said you're charged with 3 counts. You're pleading guilty to 2 of those. I'm going to go over those 2 counts with you, make sure you understand them. In count 2, what's alleged here and what you're admitting to is on or about July 20th of 2022 in Eastlake, Lake County, Ohio, that you did, while operating a vehicle, recklessly cause serious physical harm to Patricia Banning. That conduct constitutes the offense of vehicular assault. It is a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes.
Any questions about it?
No, sir.
Now, in count 3, it's alleged on or about that same day, July 20th, 2022, in Eastlake, Lake County, Ohio, that you did operate a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. That conduct constitutes the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, and it's a misdemeanor of the first degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about that? Now, count 1, you're charged with aggravated vehicular assault, which is a felony of the third degree. That would be dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about that charge? Well, then, before I can accept your guilty plea to the counts 2 and 3, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. Now, that trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial, excuse me, let me look up one thing real fast. Well, a jury trial, first of all, will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. You understand that?
Yes.
Okay, now give me one quick second. I've been looking at the license suspension. There should be a different license suspension for counts 2 and 3, mandatory suspension. Count 2,
I just,
vehicular assault. I'm looking at it. It says it's a class 4, unless I missed that, which is 1 to 5 years. And then the OVI is, what is that? 1 to 3 years.
yes, I was focused on count 3 with the, when I filled out the form, but there is a,
Yeah, the vehicular assault carries with it, in addition to any other sanctions imposed, the court shall impose upon the offender a class 4 suspension for whoever violates the offense of vehicular assault. Now, class 4 suspension is definite period of 1 to 5 years. So I'm going to add that to the form. I don't know if you want to chat real quick with. The misdemeanor is 1 to 3, right?
right.
I think you have. Oh, that's he says up to 3 years.
Okay. I just advised the defendant of that possible driver's license suspension. She understands. Doesn't have any questions for me. Thank you, Your Honor.
Okay, I'll go over with her too in a little bit. But
Thank you.
All right. So I just advised you that you have a right to a jury trial. If we did have a jury trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, by having the burden of proof, what that means is that it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all the charges, and the presumption of innocence stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, in regards to this burden of proof, since it's a criminal case we're dealing with, the burden of proof is what we refer to as proof beyond a reasonable doubt. That's the highest burden there is in our justice system. And what it actually means is the amount of the evidence and the quality of the evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charges beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that if we're going to have a trial, the prosecutor would be bringing witnesses to come into court to testify for the state by answering questions from the prosecutor. Now, once those witnesses answered the prosecutor's questions, then your lawyer would be allowed to ask those same persons questions for you on your behalf. We call that cross-examination. So she'd be allowed to ask those witnesses anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you're not required to do that, but you have the right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you don't want to. I can't make you testify, but most importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and testify at your own trial. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that's above me. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding that I will make if your plea is accepted, as well as any other issues you could have raised or brought to my attention at this time. That includes the suppression issue that was previously raised and that we had a hearing on. That issue is being withdrawn, so you're not making that challenge anymore, and you're going to be giving up or waiving your right to ever bring that challenge. You can't bring it up later. You understand that?
Yes.
Or any other issues that you could have brought up until this point. Do you understand that?
Yes.
All right. All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes.
Do you still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Sorry?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as possible sentencing goes, you're pleading guilty in count 2 to a felony of the 4th degree. This offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
Are you currently on probation or parole to any other courts or agencies?
No, Your
Do
Honor.
you have any other criminal charges pending against you anywhere?
No.
In regards to count 3, the OVI charge, it's a misdemeanor of the 1st degree. This offense is punishable by a term in jail of at least 3 days. It's a mandatory jail term of at least 3 days that must be imposed. And I could sentence you up to 180 days in jail. Do you understand that?
Yes.
Now, since this offense is a misdemeanor, if I were to impose a prison sentence on the vehicular assault charge in count 2, any jail sentence imposed on the OVI charge in count 3 by law has to be served concurrent with the prison term, meaning at the same time together. I can't run those sentences consecutive to each other, which means the maximum prison sentence you face in this case with both charges is 18 months in prison. Do you understand that?
Yes.
Now, if a prison sentence were ever imposed in this case upon your release from prison, you could be placed on what is called post-release control. We sometimes call that parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it could be up to 2 years. You understand that?
Yes.
And if you were placed on post-release control and ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if found, strike that, I'm jumping ahead of myself. If you were on post-release control and you were violating the conditions of your supervision, the parole authority could send you back to prison for violating their rules and conditions. And that period of time that you can go back to prison could be up to 9 months for each violation you committed, with an overall maximum of 50% or half of the prison term imposed by the court. Do you understand that?
Yes, sir.
All right. Now, aside from the potential prison sentence I just mentioned, there's other sanctions that can be ordered, some that are required to be ordered. You could be ordered to pay court costs in this matter, to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable in this case. Do you understand that?
Yes.
In regards to the vehicular assault charge in count 2, there's a possible fine that can be imposed also of up to $5,000. Do you understand that?
Yes.
In regards to the DUI, there's a mandatory fine that has to be imposed of at least $375, and I could fine you up to $1,075. You understand that?
Yes, sir.
So at this case, at the time of sentencing, I will have to fine you with both counts at least $375. That's mandatory minimum, and you could be fined up to $6,075. Do you understand that?
Yes.
There's also a mandatory license suspension with each count that the court's required to impose. On the count 2, the vehicular assault, there's a mandatory suspension of at least 1 year up to possibly 5 years that must be imposed. Do you understand that?
Yes.
This is what we discussed a little bit earlier. And on the OVI charge, there's a mandatory suspension of at least 1 year up to possibly 3 years. Do you understand that?
Yes.
You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a direct result of the conduct involved. Do you understand that?
Yes.
A few moments ago, I explained the possible prison sentence you face by pleading guilty to count 2. When I did that, I used the word possible because prison's not mandatory. You are eligible on the felony charge as well as the misdemeanor charge to be placed on probation, or what's called community controlled sanctions. You understand that?
Yes.
Now, just because you're eligible for that on the felony charge doesn't mean it's automatic. It means I'll consider that if that's what you're going to be asking for. I'll look at all the information presented to the court, and then I'll make the decision at that time that I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation at any point to the court, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a variety of conditions or rules for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes, sir.
Further, if you are put on probation to the court and you're violating any of the conditions of your supervision, we'll have a hearing here in court to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve more time in jail, or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, again, it could be 6 to 18 months on count 2. Do you understand that?
Yes.
Lastly, when we do come back here for the sentencing hearing, you're going to have the right on that day to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
you understand that whatever the attorneys have to say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I'm not obligated to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here today?
No, sir.
You understand all the possible consequences that could occur and what could happen at sentencing?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have her review the reports with you, discuss the questions and, discuss the issues and answer whatever questions you may have?
Yes, sir.
Are you satisfied with the advice and counsel of your attorney?
Yes.
Has she, or has anyone for that matter, made you any promises about what's going to happen at sentencing, which is influencing you to enter this plea here today?
No, sir.
Have you been threatened or coerced in any way to enter a plea of guilty?
No, sir.
Are you entering your plea freely and voluntarily?
Yes, sir.
All right, then. Do you have any questions for me at this time, Ms. Penn, regarding anything we've just talked about? What you're pleading guilty to, the rights you're giving up, the possible penalties you face? Any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No.
All right, then what's going to happen at this point, the prosecutor here, she's going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her and what she has to say, because I'll have some follow-up questions for you, all right? Ms. Mulligan?
Your Honor, the state would be prepared to show that on July 20th, 2022, in the city of Eastlake, Lake County, Ohio, the defendant was driving an automobile with Patricia Banning in the front passenger seat. The defendant drove up off the pavement on Lakeshore Boulevard, over the curb, onto the grass, and straight into a tree, causing a crash into the tree, which injured Ms. Banning. Ms. Banning suffered lacerations to the head, face, and arms, resulted in scarring and extensive bruising. She had extensive bruising of her abdominal area that required follow-up treatment to drain the internal wounds. She experienced a period of prolonged pain and a temporary substantial disfiguration. At the time of the crash, the defendant was driving the automobile while under the influence. We would show evidence that she had a strong odor of alcohol. She admitted that she had been drinking. She had slurred speech and red, glassy eyes.
So, Ms. Penn, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial in this case?
Yes, Your Honor.
And what, if anything, do you have to say about those facts as she just presented them and represented them to the court? Are they accurate? Did you do as she said?
Yes, they're accurate.
Very well, then. Regarding count 2, charging with vehicular assault, a felony of the 4th degree, what is your plea to that count?
Guilty.
Regarding count 3, charging with operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a 4-page document. It's called a written plea of guilty and judgment entry, which explains everything we've just gone over. Before I can accept your guilty plea, I need to be assured you understand what's in this document, that you sign it here in court. Now, my understanding is that before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Ms. Springer, is that accurate? Did you read this to your Ms. Penn and review it with her?
Yes, I did.
And in doing so, did she indicate an understanding of its contents to you?
Yes, Your Honor.
Is that correct, Ms. Penn?
Yes, Your Honor.
Any questions for me about what's set forth and contained in this document?
No, Your Honor.
Now, it appears that on the last page, the top of the last page, you signed the document. Did you, in fact, sign it?
Yes, Your Honor.
And Ms. Springer, did you witness that?
Yes, Your Honor.
Ms. Mulligan, you as well?
I did, yes.
Thank you. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer. She was advised of all her constitutional rights and made a knowing, intelligent, and voluntary waiver of those rights. The court also does find the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 2, vehicular assault, the felony of the 4th degree in violation of 2903.08, as well as count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a misdemeanor of the 1st degree in violation of 451119A1A. Count one will get dismissed as agreed to by the parties at the time of sentencing, but I am going to defer sentencing, order of pre-sentence report investigation, drug and alcohol evaluation, victim impact statement. I'll continue defendant's bond at your own recognizance. What all this means, as far as bond goes, there's nothing more you need to do about that. Your bond's being continued, and you already signed the paperwork. But you have to remember that when you're on an own recognizance bond, you have to show up at all future court dates. We have to show up at all future court dates on any bond. But if you fail to appear when you're released on an own recognizance bond, that's a separate felony you can be prosecuted for and get up to 18 months in prison in addition to whatever would happen here. So it's obviously important you show up at all future court dates. You understand that?
Yes, Your Honor.
Mr. Shadow, when is our sentencing hearing so we can make sure she's aware of that?
The date is July 31st at 9:45.
So July 31st at 9:45 a.m. will be your sentencing, so you have to make sure you're here for that, all right?
Yes.
Now, the pre-sentence report that I've ordered, the purpose of that is so I can get more information about you. The way the probation department puts that report together is they're going to conduct an interview with you. They're going to ask you questions, administer tests. It's important that when you meet with them and speak with them, that you're open and honest with them in regards to your responses, because they're going to check and verify everything you tell them. And if they discover you're misleading them in some way, they'll let me know that, and I would obviously consider that at sentencing. You understand that?
Yes.
All right. So you're going to leave here right now and go to the probation department, meet with them just to sign some initial paperwork and get some dates to come back. So make sure you go over there. Your attorney will show you where that is, all right?
Yes, Your Honor.
All right. Ms. Mulligan, anything else?
No, Your Honor, thank you.
And then I assume the motion's withdrawn then at this point?
Yes, Your Honor.
All right, anything else, Ms. Springer?
Nothing further. Thank
All
you.
right, thank you all.
All rise.